and welcome to today's Law and Ordinary People programme. The aim of this show is to tell you your legal rights and to try and help you keep out of trouble. So if you do ever have any legal questions or just something that you don't really get, feel free to send them in to us at FECTV, either on Twitter, on Facebook, or through email. You can get me at brietheffernan@fectv.com. Firstly, I just want to give you a bit of legal jargon. You have to note that while we do our best to give you accurate legal information, the law is always changing. And this is general legal advice. If you want specific legal advice, you should talk to your own solicitor. But firstly, someone emailed us in with a question. It was Christina O'Dwyer, and we'll show you the email now. She emailed to say, "Hi Bríd, I was recently in a shop and my handbag hit off a wine glass, which was part of a set of glasses on display. The glass fell off its shelf and broke on the ground. I apologised to the owner, but she brought a sign behind her which said, 'You break it, you buy it,' to my attention. I paid up just to get out of there, but are you actually legally obligated to buy something just because you broke it?" Christina. So thanks for the question, Christina, and I'm really sorry that you had to pay that person for the wine glasses. You could have put up a bit more of a fight, because the short answer to your question is no, there's not actually a law that requires you to buy something. There's no "you break it, you buy it" law on the statute books in Ireland, so you could have made a bit more hassle for the shop owner. Liability really depends on the circumstances of the breaking of the glass. So as there's no law, there's no black and white law, it depends on contract law or negligence, common law. So under contract, the idea of the sign is obviously firstly to scare you, and secondly to convince you that there's a unilateral contract created by having "you break it, you buy it" on the wall. Except not all unilateral contracts are actually contracts as far as contract law is concerned, because then you could put anything on a wall, like you walk into the shop, "You pay me €5" or something, which just wouldn't make sense. So in order for a unilateral contract to actually capture the person who's coming into it, there needs to be express acceptance by that person, but like you paid or something, or like you really agreed to it. But by walking into a shop, there was no express agreement. Also, it's missing one of the other elements of a contract, which is always necessary. Every contract has to have offer, acceptance, and consideration. And there's no consideration here. Consideration is money or money's worth. So you can't just make a contract for no reason. There has to be a reason, something at the core of it. So you didn't pay anything to come into the shop. You didn't get any benefit from going into the shop. So I don't think that consideration could be argued that it passed. So I don't think the contract law side will work. However, there is the other option, which would be the law of negligence, which is also common law established by the courts. The standard is that you took reasonable care not to break the glass, because you can't go around like a bull in a china shop knocking stuff everywhere you go, because obviously then it makes sense that you would have to pay out if you go around acting this way. Negligence goes under the law of tort. Torts are suing people for something. So if you're liable in negligence for something, the answer is that you'll put the person back in the position they were in before you did that negligent or wrong act. So the duty is not to cause damage that is reasonably foreseeable. It's very easy, reasonable man standard, very obvious. So technically I would say negligence they could get you on. However, what do you have to pay? What damages would you have to pay? There's 2 points to that. There might be contributory negligence. The glass could have been put somewhere that they wanted you to knock it nearly. And if it was really stupid, you might have been half at fault and they might have been half at fault. So they take 50% off of how negligent you were. So 50% off of the award. Also, the tort negligence will put you back in the position that you were in before this thing happened. So you shouldn't have to pay the full amount for the glasses. You should only have to pay them the cost of the glasses, which makes sense. So technically, I wouldn't be giving them the full amount for the glasses. The honest answer is probably you should try and discuss it, and for the store's own policy, they should probably just let you off or say, give us a tenner or something just to cover our losses. So I wouldn't have paid up the full amount of money, but at the same time, for the sake of an easy life, I can see what you did. The next question comes in from Marion Lockman, who emailed us again at breeteffernan@fectv.com. And Marion says, "Hi Breed, I'm lucky enough that I don't have a HMV gift card, but I am interested to know, what does administration mean? Some people say HMV is in administration and some people say it's not. What is the answer? Also, I don't get why they don't honour the gift vouchers because they've already got the money from the people who bought them. It's a bit stupid, really. Kind regards, Marion." So Marion, you actually have a really good question there, and I'm so glad somebody asked this because nobody actually gets the difference between examinership and administration and receivership. And it's so simple, and everybody should know because it's really straightforward. So firstly, I need to explain, HMV in the UK is the parent group of HMV. HMV Ireland is the subsidiary or like baby company to come from the parent HMV. So in HMV in the UK, they're in administration, which is the English version of examinership. So I'll tell you what examinership is in a second. But the Irish branch of HMV are in receivership, which is totally different to examinership and administration. So examinership, which is like the Irish version of what HMV in the UK is when a company is insolvent, which means unable to pay its debts as they fall due. Generally, a creditor can serve a notice on a company threatening them to have them wound up, and then the company goes to the court to look for protection from their creditors, as in to prevent them from having them wound up and things. And if the court thinks that the company is viable and will trade again, and it would be a shame to have it written off because they're going through a bad period, they can allow them to have protection from their creditors for a period of up to 100 days. So a person known as an examiner is appointed to go into the company and make a scheme of arrangement or like a solution, how they're going to get out of this problem. And then the creditors and the court will have to approve that that's going to happen. So administration is just the UK version of our examinership. Then there's receivership. And this happens when a company is given money or credit or something from a bank or a building society, and it pledges assets as security. So a contract is written up between them, and it's given the power to appoint a receiver if they don't pay back the money in the way they're meant to do. And generally, I mean, negotiation will happen and things, and they don't want to send a receiver in, but if the company just isn't giving them the money or doing what they're supposed to do, they have to. So sometimes if an asset is a going concern, like a shop, the receiver just wants to get the best money for it. So he might sell it as a going concern because that just makes sense rather than just wrapping everything up and then there's no money left for anyone. But neither examinership, administration or receivership necessarily means that the business is being wound up. So the appointment of a receiver to HMV, which is what's happened in Ireland, does not necessarily mean that the gift vouchers are invalid. It definitely does not mean they're invalid, whatever about anything else. So it is definitely wrong for HMV not to accept them now. There's three things that could happen to a gift voucher in different circumstances. In a receivership, like here, there's still a full value, and it's not legal to write them down. That's not possible at all because the receiver is just taking over the running of the business. The second one is in an examinership, and then it may very well be written off, but only after a judge says, yeah, let them go. The other one is in a liquidation, and in which case the liquidator who's gone in to wind the company up can write off the gift vouchers because they're credit. And technically the holders of gift vouchers are unsecured creditors, and there's order of priority of creditors and companies. So the best person you could actually be is a taxman because they're priority creditors. They're the top. They will always get their money if there's any money to be got. Then the one right underneath that is secured creditors. And secured creditors are people who have an agreement or a debenture, which is just the fancy name for the agreement, with the company saying if something does happen or you go belly up, we'll be the first to get paid. Always us. So banks and sort of big traders and things might have secured credit agreements with the HMV or whoever is in question. But you as the person with your little gift voucher never asked for anything more than your little gift voucher because you bought in good faith and you assumed it would be all good. So unfortunately, you're an unsecured creditor, like normal people usually are, normal consumers. So that's the list of priorities, and unfortunately, that's pretty sad. But that hasn't happened yet. HMV is not being wound up, it's not in liquidation, and they've not been to a court, and a judge has not said, write these off yet. So it hasn't happened anywhere. Usually liquidation does follow a receivership, but not necessarily. I mean, HMV may be taken over and it may continue trading. So interestingly enough, I looked at what was going on in HMV and I looked up section 295 of the Companies Act 1963, which if you're a nerd like me, you quite enjoy doing. And it says, if any person being at the time of the commission of an alleged offence an officer of a company which is subsequently ordered to be wound up by a court or subsequently passes a decision to voluntarily wind up, has by false pretences induced any person to give credit to the company, he shall be liable to imprisonment for a term not exceeding 2 years or a fine or both. So technically, that would lead one to believe if HMV does go on to be wound up and things, if that happens, technically whichever officer of HMV said, yeah, don't accept those gift vouchers could be liable under this legislation. But I sent my proposal to the Office of the Director of Corporate Enforcement, and we'll show you a copy of their response. I got onto them, I said, you know, this is appropriate, will this happen to HMV? The Office of Director of Corporate Enforcement is meant to enforce what companies do and regulate and all this, but I've never noticed them to do very much, even though they're paid to. Their response to me said, Dear Ms. Heffernan, I refer to your email in relation to HMV and whether Section 295 of the Companies Act could be appropriately used against the directors of the company. The ODCE cannot comment on probable situations. We can only deal with actual factual matters and breaches of company law that have happened, as are reported to this office. For information, I attach a link with loads and loads of information which I already knew. So that's all that'll probably ever come of that, but if anything ever happens, I tipped the ODCE off on what they should be doing. So that's all we really have time for today. I hope I've filled you in on what's going on, and I hope I answered Marion's question about HMV well enough. So hopefully they will one day, if the receivership goes well and things, actually accept the gift vouchers. So we wouldn't throw them away yet or trade them in for a pizza in Sober Lane quite, but because they're not worthless, but I wouldn't bet your house on it either. So now you know, the English ones are in administration, Irish ones are in receivership. I hope you get it. If you have any more legal questions that you just want us to give you an honest, plain English answer on, feel free to send them in to briteheffernan@effecttv.com, and I hope that you got something out of this evening. Thanks for joining us on Law and Ordinary People, and see you next week.